Today, we're going to get into a case that is just a classic legal puzzle. It's a story about the hunt for a dangerous criminal that slams right into a person's most fundamental rights. And it all forced a court to make a choice that, honestly, seems almost impossible. It all came down to one blood sample and one very, very carefully chosen letter.
And this is the question at the heart of it all. When the police have a really strong hunch, but they don't have that crucial piece of evidence, just how far can they go? Is it okay to use a little bit of, well, deception to get what they need, even if it means the suspect doesn't really know the whole story? This case puts that exact question on trial.
All right, so let's set the scene. It's late 1989. Two brutal sexual assaults happen, and at first they don't seem connected. But they put one man, a suspect we're just going to call JRB, right on the police's radar. Okay, so here's how it all went down. In October, there's this horrible attack on a senior citizen. The police get DNA evidence from a blanket, but they have no idea who the attacker is. Then, a couple months later, in December, a second attack. This time, the victim, an exotic dancer, can positively identify her attacker as JRB, so he gets arrested. Now, here's the key. The police have him in custody for that motel assault, but they have this secret gut feeling that he's their guy for that first, much more serious attack on the senior. So now we're at the police station, and this is where it all gets incredibly tricky. What happens next looks like just a series of routine requests, but actually, they're so carefully planned, and the whole thing, the entire case, really pivots on a single letter, the letter S. So JRB's in his cell. He's already chatted with his lawyer who gave him the classic advice, keep your mouth shut. So first, the cops come in and ask for some hair samples. He says, okay, sure. Then about 15 minutes later, they're back. This time they want a blood sample. And JRB, he was confused. He even said later that he just didn't get it. Why on earth would they need blood? He knew there was no ejaculation in the motel attack he was actually arrested for. And this right here is the crucial disconnect. JRB is thinking, okay, I'm cooperating with the investigation for the crime they arrested me for, but the police? The investigating officer later testified that the main thing on his mind was the other crime, that unsolved attack on the senior citizen. That's what they needed his DNA for, to see if it matched the stain on that blanket. Now, before they took his blood, the police wanted to be, as they put it, very cautious. So they actually called a Crown prosecutor, and the prosecutor told them the exact words to use on the consent form. And look at that word, investigations, plural, not singular investigation. It seems like a tiny thing, but that little S was deliberately chosen to cover more ground than just the one case JRB knew. In fact, if there was any doubt, one of the constables just flat out admitted it later under oath. He said JRB had no clue that his blood was really for the senior citizen case. So yeah, he technically signed a consent form, but it wasn't what you'd call fully informed consent about the real trouble he was in. So the police have what they need. They've got the signed form, they've got the blood sample, they send everything off to the lab for analysis. And the results that came back? Well, they seemed to slam the book shut on that brutal attack. And the science was just, wow, absolutely staggering. The lab developed a DNA profile from JRB's blood, and they compared it to the DNA from that semen stain. And it was a perfect match. What are the odds of that being a coincidence? Less than 1 in 78 billion. I mean, with a B. So JRB was convicted at his trial. Case closed, right? Well, not so fast. Believe it or not, this was far from over. JRB's lawyers appealed the conviction, and suddenly the entire argument changed. The question wasn't, did he do it anymore? The DNA science pretty much settled that. The new question was, how did the police get the evidence to prove he did it? And this is where we get into some really fundamental stuff in Canadian law. The Charter of Rights and Freedoms, specifically Section 8. It says that every single person has the right to be protected from unreasonable search or seizure. And taking blood from someone's body without their valid, and this is the key part, their informed consent, well, that's a seizure. The court had to figure out if it was an unreasonable one. So the judges had to wrestle with this really important legal distinction. Is a blood sample real evidence? Something that just exists out there in the world, like a weapon police might find? Or is it conscriptive evidence? Something the accused is forced, or in this case, tricked, into helping create for the police. And this isn't just semantics. It's a huge deal, because using conscriptive evidence can make the entire trial fundamentally unfair. And this is where the majority of the appeal judges landed. Their thinking was, look, the DNA on that blanket was basically meaningless on its own. It only became evidence once it was matched to JRB's blood. So by tricking him into giving the blood, the police had essentially forced him or conscripted him to create the very evidence that put him away. And that, they said, violated his rights and made the whole trial unfair. But, and this is a big but, there was a really powerful counter-argument from the dissenting judge. He basically said, hold on a minute, this DNA evidence is as reliable as it gets. It proves he's guilty. To just throw that evidence out because of how it was obtained, he argued that letting a proven, violent criminal walk free would actually do more damage to the public's trust in the justice system.
So you see the problem, right? The court was totally stuck between a rock and a hard place. On one hand, you've got the principle of a fair process for every single person. On the other hand, you've got the need to get a just result for a horrible crime. What do you prioritize? Rights or results?
The panel was made up of 3 judges, and the final vote, well, it was not unanimous. It came down to 2 against 1. And in a decision that I'm sure shocked a lot of people, the court overturned JRB's conviction. He wasn't going to get a new trial. He was free to go.
So you're probably asking yourself, why? Why would they do that? Well, here was the majority's thinking. They decided that protecting the long-term integrity of the justice system is more important than winning any one single case, no matter how awful. And it set this huge precedent. If the police want your consent to take something from your body, they have to be straight with you about why they want it and what they think you did. The fairness of the process, in the end, won out over the certainty of the result. The court even acknowledged how tough this decision would be to accept. They used this powerful quote to explain their thinking. I mean, it admits that it's hard to watch someone who is factually guilty go free, but it calls that outcome the price of freedom, arguing that the rules that are designed to protect all of us from the state have to be applied to everyone, even to the guilty. And that brings us right back to where we started. The police used a trick, a clever bit of wording, to solve a horrific crime and get a predator off the streets. But the court said that trick went too far, and it violated rights that protect every single one of us. So where would you draw that line? It really makes you think, what's more dangerous in the long run? A guilty person walking free, or a system that's allowed to bend the rules to make sure they don't?